Welcome, everyone. I am Jeff Lewis.
And I'm Tim Kowal. Both Jeff and I are certified appellate law specialists and uncertified podcast hosts. We try to bring our audience of trial and appellate attorneys some news and insights they can use each week in their practice. So if you find this podcast helpful, please subscribe and recommend it to a colleague. And if you don't find it helpful, send it along to opposing counsel.
Yeah, and if you lose a ruling, send it to your judge overseeing your case. And a quick announcement, this podcast is sponsored by CaseText. CaseText is a legal research tool that harnesses AI and a lightning-fast interface to help lawyers find case authority fast. I've been a subscriber to CaseText since 2019, and I highly endorse their service. And listeners of our podcast will receive a 25% lifetime discount available if they sign up at casetext.com/CALP. That's casetext.com/CALP.
Yeah, and then here's just a hot referral for CaseText. We were just talking before we hit the record button, Jeff, about this question that we're going to talk about today. And have cases settled this? And I had looked up on CaseText, and you looked up on CaseText. If we couldn't find an answer, we know that it must be an open issue.
Well, more importantly, neither of us took the 35 minutes it takes to log into Westlaw to get Westlaw, past the sign-in and the authentication and the blah, 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 to, CaseText, you just log in and get rolling with your question.
I was pretty much sold on CaseText when I could log in less than 3 seconds. So that is a big selling point. Well, so Jeff, we decided we wanted to talk about today an issue that comes up a lot in both of our practices. The issue that most often drags my appeals back into the litigation world is the issue of attorney fees and costs. So let me paint a quick picture of a common scenario, Jeff. So say the trial has not gone your way and you're getting geared up for the appeal, but while you're focusing on getting ready for the appeal, the prevailing party gets a substantial award of fees and costs. And so now you have a new set of problems. Like, do I have to separately appeal from this award of fees and costs? And how can I stay enforcement of the fees and costs award? Are they going to come after me to start, execution liens on the fees and costs award? If I win my appeal, hopefully, knock on wood, I'm going to win this appeal. It's a righteous appeal. Does that make the fees and costs award go away automatically? Can I just ignore the fees and costs and hope that I'm going to win that the underlying appeal of the judgment? So Jeff, I thought we'd just start out by asking, we kind of go through a lot of these questions, see if we can answer them for our listeners. So first question conceptually is, when do you have to appeal that award of fees and costs? Do you appeal it as soon as the minute order comes down, or do you wait for that, signed, formal, pretty looking formal order, or wait for it to be added to the judgment?
Right. Yeah. And so many judges have different practices about doing an amended judgment where they insert costs and attorney's fees later in a blank, or a brand new judgment, or they just let the clerks enter costs and fees on the judgment on the clerk's roll. I have to tell you, Tim, there are many areas of appellate procedure where I can rattle off my head. 60 days for a notice of appeal, counter designation rules. This is an area in terms of appealing attorney's fee awards that 100% of the time I always go to the Rudder Group, because there's lots of traps for the unwary here.
Yeah, that's going to the Rudder Guide is always a sound move. Also, calling the co-host of the California Appellate Podcast would be a sound move.
You're too busy and too expensive for me to rely on. But yeah, I thank you for the offer.
I think we covered a case on this. The answer to the question is that you have to appeal from the minute order. That minute order awarding fees is the appealable post-judgment order under CCP 904.1A2. And if you sit around and wait, thinking that the court is going to sign a formal order or amend the judgment, the court may well do that, but that does not restart your time to appeal. And we had covered that before. We'll post a link to this in the show notes. Liang versus Shi. This was a non-published opinion, but that exact issue came up. The appellant waited, figuring, well, I'll get the judgment amended or I'll get a formal order. And by that time, too late. Appeal from the minute order was untimely at that point. The appeal of the minute order awarding fees. So be careful about waiting around. As soon as you get that minute order, it doesn't have to be signed or formal. That minute order awarding fees and costs is the appealable order. All right, and also be careful about trying to amend the judgments generally. Not only don't wait around for it, but be careful when you ask the judge to amend the judgment. We covered this also. I'll post a link to that in the show notes, that amendments to a judgment during the appeal was reversed violate. No, that's
Yeah,
not the one I'm thinking about. Oh, it was but the Court of Appeal didn't like it when the trial court amended the judgment because it created what the Court of Appeal called a quote procedural mess.
yeah. Well, I mean, let's be clear. If there is an appeal of the merits of a case and then there's a fee award, the trial court can always amend the judgment to add the fees and costs. What the trial courts can never do is if there's an appeal of the merits and an appeal of the fees and costs, at that point, the trial court can't be messing around by amending or interlineating old judgments.
Right. Now the court can, write in the number if the original judgment had said that the prevailing party is entitled to fees and costs of blank, then the clerk can interlineate the number there. But in this other case that we'll link in the show notes, there was a finding of prevailing party that was changed, and that was amended in the judgment, and that was a big no-no.
Yeah, for sure, 100%.
Okay, so now we know when to appeal from the award of fees or costs. Now the next question is: Are the costs and fees award automatically stayed on appeal? And the short answer to that, sometimes deceptive answer, is yes. Awards solely for fees or costs are automatically stayed on appeal without the need to post a bond.
Routine costs, not involving an anti-SLAPP motion.
Okay, put a bookmark on that, Jeff. We're gonna we're gonna reprise our argument on that in a moment. But Jeff, you wanted to also talk about just do a quick city bus tour on stays and bonds of the underlying money judgment.
First question client asks me or should ask me, or trial lawyer asks me or should ask me is, can this be executed on pending appeal in terms of either the costs or the damages? And costs normally are stayed, fees normally are stayed in a non-SLAPP context. As to the damages, it's not stayed. The plaintiff can execute pending appeal. And so the things that I go over with clients are, one, don't forget about the discretionary request for a stay in the trial court. Sometimes trial judges feel strongly their decisions are right, and sometimes they're like, on the fence, go up to the Court of Appeal, and they might be receptive to a motion for discretionary stay of execution pending appeal.
But that discretionary stay, are you referring to CCP 918 that provides that temporary discretionary stay?
Correct, for a limited duration of time. And then for a longer term, you can always post a bond. And the question is, how much does it have to get posted and what's it going to cost the client? And in terms of how much, it's usually 1.5 times the amount of the judgment. That's the bond amount. And how much is that bond usually the client? Well, it depends on the client. I've represented Fortune 200 companies on appeal where the bond amount is very small. They're very, or in terms of the premium or the cost to issue that bond, because the bond company surety thinks it's a very small risk. On the other hand, Tim, if you need to post a bond, you might be more of a risk than a Fortune 200 company. That might be a higher premium. That's my experience. But generally, what's your experience?
Yeah, my experience, I typically use CSBA, the Court Surety Bond Agency, and they're usually across the board. Their premium rate is 1% per year, 1% of the face amount of the bond, with the first year's premium being payable up front.
Oh, really? Is that regardless of the financial viability of the appellant? Just a straight up 1%?
That seems to be flat. I haven't seen any deviation in my experience.
All right. And then, you pointed out in our show notes that you always have to have a conversation with the client or trial counsel that, you could stay this judgment, but it'll be earning 10% pending 2-3 years of the appeal. Would the client want to write a bigger check at the end of the process?
Always important to remind the client of that early and often, because sometimes they will lose sight of that and months go by, and then they're reminded that, oh my God, I've got, if this is a 7-figure judgment that we're appealing, suddenly he's got six figures in interest that's already accrued after the first year of the appellate process.
Yeah. And then finally, we've covered this on earlier episodes of our podcast. There is a process to either personally pledge or have others offer personal guarantees in lieu of a formal bond from a surety. Rarely used, but we've come across it 1 or 2 times in our joint cases, right?
the discussion is too interesting not to bring it up, but I've not ever found any takers yet. That is
Yeah.
If you're ever interested in the concept of a personal surety, contact Jeff or me about that. We'd be happy to talk about it with you.
Okay.
All right, so we had started this conversation about bonds and stays of enforcement of judgment, Jeff, by talking about judgments purely for fees or costs, and then we talked about judgments for money judgments and how to get stays of those. But what if there is an outstanding money judgment and then there's also fees and costs added to it? Is the cost award automatically stayed pending the appeal? How do we think about that problem, Jeff?
Well, this is your domain, the Quillis case, in terms of the impact of paying the money judgment and leaving only the costs or attorney's fees as the unpaid portion. I mean, there's some strategy involved here.
Yeah. The strategy usually is, if the client has not already found a way to bond and stay the underlying money portion of the judgment, then the added costs and fees become part of the principal amount for purposes of determining what the bond amount would be. But the strategy that you raise is, well, what if the underlying money judgment could be paid? What if it's a relatively small amount? You've got one of those inverted awards where the underlying money judgment is fairly small, but the costs and fees are very large. And you could think about simply paying the underlying judgment amount, and then you're left only with the award of costs and fees, which may be subject to the automatic rule of an automatic stay. Now, there's another possible wrinkle there, and I've been confronted with this argument, Jeff, that okay, the underlying judgment amount is paid, leaving only the costs and fees amount, which would be subject to the automatic stay rule. But can you go forward and still appeal from the underlying judgment? So you've paid the underlying judgment, but you still want to challenge it on appeal, and you also want to appeal the costs and fees and enjoy the automatic stay rule of the costs and fees. Does that work out? Because I've been confronted with this argument that no, you can only as long as the judgment is being appealed from, the costs and fees become part of that judgment, so you would still have to bond it in the amount of 150% of an admitted surety bond.
Yeah, I think it's a solid argument. Candidly, I've never litigated the payment of judgment question. One thing you always have to be aware of when you're talking about paying part or all of the judgment is the issue of waiver. If you simply write a check without duress, without a debtor's exam being noticed, without wages being garnished, there are some arguments that maybe one or more issues on appeal might be waived. So you want to have a good record that you're paying under duress as opposed to conceding the liability pending appeal.
Right. That is an important concern about not when you pay off that judgment amount, you want to make sure it doesn't lead to a waiver or forfeiture argument. All right, here's another related question about the let's say that you have one of these inverted situations where you've got a relatively small judgment, you've got a huge cost and fees award, and you really want to get that stayed, and you would like to enjoy the automatic stay rule, but whether you can get it automatically stayed or maybe you're even willing to post a bond for it if you feel that's necessary, what happens if the fee award is pretty defensible? It's well within the trial judge's discretion. You don't really have a good ground to attack it on appeal. You don't want to file a frivolous appeal, but absent an appeal, there's no way to get a stay of enforcement. What do you do there, Jeff?
Yeah, that's a tough one. You might have to call your ethics hotline, because I'm always of the mind you cannot appeal a fee award if you don't have a good faith argument. For example, if you don't have a court reporter's transcript and you don't know what was said during that hearing, and there's not some clear legal error, simply filing an appeal to delay payment or otherwise, I don't. It's a problematic area.
Well, here's one possible way out, Jeff, and this is a reminder to our listeners of the case that we talked about some episodes back, and we'll include a link to that. I don't have the case offhand, but it was the case that pointed out that there is a problem with the Judicial Council memo of cost form. You remember what that problem is, Jeff?
Yeah. It's that there's no signature line under penalty of perjury. There's just a counsel signature line without the statement that it's under penalty of perjury. And I think it was raised in an unpublished decision that perhaps that's a problem.
It was actually a published decision, but there was and the published decision said, well, it's close enough. That was the majority of the panel, but there was a dissenting opinion that said no, it's not good enough. The memo of cost is what makes the prevailing party's initial burden of proof to shift the burden over to the opposing party to produce evidence to show that the costs were not actually incurred or not available. And without that initial burden having been shown, the memo of cost has to fail on its face for lack of a verification under penalty of perjury. So that is an issue that if the prevailing party in your case has made use of the Judicial Council form memo of costs and signed that without some other declaration under penalty of perjury, you may have a good ground to challenge that entire memo of costs as failing the rule that it has to be verified under penalty of perjury.
I rule that argument is colorable.
I think so. If you've got a sitting Court of Appeal justice who has written a dissenting opinion, and it's a very lengthy, does a deep dive into the statutory legislative history on what is required in a verification. So I think that's a defensible argument. I have to say that because I have adopted that argument in one of my appeals.
Okay.
Okay, so now a few moments ago, Jeff, we put a bookmark on this question of whether all fees and costs are subject to the automatic stay of enforcement rule, and you made a reference that only non-routine costs. What did you mean by that, Jeff? Only non-routine costs are automatically stayed on appeal.
Well, first of all, you call it a question. It's more of an issue of settled law. That the spirit and legislative intent of the anti-SLAPP statute means that fee awards or awards of fees and costs pursuant to the defendant in an anti-SLAPP case, those types of awards are considered a non-routine award of costs, and that plus the legislative intent behind the anti-SLAPP award or anti-SLAPP law has been construed by the courts to mean that these fee awards are simply not stayed pending appeal or not automatically stayed.
Well, and you have case law to support that. That's the Dowling versus Zimmerman case. You'll see that in all of Jeff's fee motions. But the legislature has abrogated this routine versus non-routine distinction way back in its amendment in 1993. And that amendment left all costs subject to the automatic stay rule, except for the three categories of costs defined by statute, and those do not include anti-SLAPP fees. So Dowling, it seems, did not catch the drift of that amendment, but the Quiles versus Parent Court of Appeal decision from 2017 noticed that something was amiss and reasoned that, quote, nearly all post-judgment awards of costs in California courts should be subject to the automatic stay. So we, Jeff, you and I discussed this and bandied this about back in episode 47, and I have my published article on this last year in the California Litigation magazine. Will include links to those in the show notes.
Tim, publishing that article in Litigation magazine does not make your argument stronger, but congratulations. So I had an interesting Stump Tim question or a Stump Jeff question about sometimes trial courts will award fees not to the defendant in an anti-SLAPP case, not to the person who brought the anti-SLAPP. Sometimes a trial court will find that an anti-SLAPP motion is frivolous and award attorney's fees to the party, the plaintiff usually, who had to oppose an anti-SLAPP motion. And one of my arguments about why there's no stay of fee awards normally for when a defendant prevails and gets a case dismissed is there's a policy interest of making an anti-SLAPP defendant whole and getting him out of the case as quick as possible. When a plaintiff successfully withstands an anti-SLAPP motion and gets fees because the motion was frivolous, I'm not sure those same policy interests are implicated. And I wonder what would happen If somebody tried to enforce those fees pending appeal, those fees would be considered stayed pending appeal. What do you think, Tim?
Right. So you're talking about normally when when you're dealing with anti-SLAPP fees, it's the prevailing defendant who's prevailed on the anti-SLAPP motion gets awarded his or her fees. But every now and then, a defendant files a meritless anti-SLAPP motion, and the plaintiff is entitled to fees if the court finds that the anti-SLAPP motion was brought not in good faith. And so under my Kowal's case, the answer would be easy, that all fees, including SLAPP fees, are considered to be costs that are automatically stayed pending appeal. But then I suppose that it's possible that fees against a defendant in this situation, the defendant who's brought a bad faith SLAPP motion, might that be considered a sanction? And if it's an award of sanctions, are awards of sanctions, and this is a Stump Jeff question back to you, Jeff, are monetary sanctions awards automatically stayed on appeal? Are they considered attorney's fees, or are they more like money judgments?
Well, let me say on the first question, your instinct is right. There have been a number of cases construing sanction awards to plaintiffs where the courts have analogized or relied on 128.5 or 128.7, the sanction statutes, for procedure on how to proceed with these fee requests. And so it is not a stretch to think that a award to a plaintiff in an anti-SLAPP case for having to oppose a frivolous SLAPP motion, that's really a sanction, not so much an award of non-routine costs within the meaning of doweling.
Yeah, that's a space to watch, because I have not seen those issues taken up. So there's an arguable question of whether those fees awarded to the successful plaintiff who successfully defends a bad faith SLAPP motion and gets fees for it, is that a sanction award or is it an attorney's fees award? And then even if it's a sanction award, I don't know the answer to whether sanctions award are automatically stayed on appeal.
My gut tells me it is not automatically stayed, because the statutes and cases talking about the automatic stay refer to attorney's fees and costs. Sanctions are more, sometimes the trial courts impose sanctions amounts that have nothing to do with attorney's fees and costs. And so my gut tells me those are not automatically stayed. But I will say this, anecdotally, in my experience, when a notice of appeal is filed properly from a sanctions order in the proper form by the proper party, anecdotally, trial courts will often stay enforcement pending resolution of the appeal.
Although remember, under CCP 918, the trial court's discretion to stay enforcement is limited to only up to 10 days after the notice of appeal could have been filed. So it's a relatively short stay. It's not going to last you the duration of the appeal.
I'm going to tell you this. I can't remember ever handling an appeal of a sanctions award like this, where the trial court did not say either it's part of the sanctions award or in a subsequent minute order, yeah, well, it's a stayed pending appeal. But that's just my anecdotal experience.
Yeah, interesting. I wonder if there's a different way you have to structure, the court would have to structure the sanctions award to make it not payable for a certain amount of time. Or you could say, I guess the court could say it's not payable until after an appeal.
Well, and then I suppose the other side the prevailing party could try to enforce and then go up to the Court of Appeal on supersedious or other grounds to try to get it stayed.
Yeah, that's true. Okay, well, let's jump to our next topic, Jeff. So now we're going to fast forward. Let's say, because we've covered when you have to appeal from the costs or fees award, and then we've covered how to get them stayed pending the appeal. So now let's fast forward and say you've reversed the underlying judgment. So great news. But what happens to your appeal of the fees? Do you still have to go and litigate the fee award, Jeff?
Yeah.
Or is it automatically reversed, because the premise for the fee and cost award was the judgment, and if the judgment's gone away, then the fee and cost award has to go away too.
Yeah, like magic, it disappears.
Yeah. And that was covered in the Dr. Leavell case that we talked about. Last year. This was Mid Wilshire Property versus Dr. Leavell, and it was real interesting what happened here, because the appellants had reversed the judgment. The briefing had not even begun on the fee appeal of almost $500,000. So the parties were able to get together, and they jointly stipulated to request some summary reversal of the fee award, and the court went along with it. So that may be a strategy. Because once you're up on appeal with the fee award, the trial court obviously can't vacate it, because the trial court has no jurisdiction over the fee award when it's up in the Court of Appeal. And I think the appellant was a little bit too weak in the knees to dismiss the fee appeal, because I don't know the upshot of that. Does that wind up leaving it affirmed on the merits?
Right. Yeah, that's a great. I've never litigated that. That's a great question.
Yeah, so I think you would need the Court of Appeals intervention. So if you think about it before you get to that point, and you are you're briefing and maybe an oral arguing the underlying judgment, and you've still got a fee appeal kicking around there, you might remind the Court of Appeal that, hey, by the way, if you do decide to reverse, you might just go ahead and dispose of the fee appeal as well summarily, because it automatically goes away, because the premise for it will disappear when the judgment's vacated.
Yeah. And here's an ethics corner quandary for you, Tim. A new segment on the show called Ethics Corner. Suppose you have an issue where there's a contingency case where, Tim, you've received a big fee award, let's say on a slap or other contingency matter, and the client never paid any fees, so the fees go in your pocket, and then the other side appeals, and there's a risk that the case might be reversed, and that the client would have to disgorge those fees to the other side, and the client at that point in time wouldn't have those fees in his pocket. They'd be in your pocket, Tim. Mm-hmm. I wonder, when you've taken a fee award on a contingency case, the fees are in your pocket, there's some sort of risk, disgorgement, and maybe payment of interest upon that disgorgement, if there are duties of disclosure and conflict waiver at the outset of the appeal, where you tell the client, if there's an appeal, here's what's going to happen to the money in Tim's pocket.
Oh yeah, I think that's a great quandary. I would I think that's all the more reason not to take a penny until that that judgment is final. If there's still an appeal pending, that's that award, any monies collected or enforced on that money judgment are subject to disgorgement if the judgment is reversed on appeal.
Well, don't take a penny unless you have maybe a contract. You've dotted the I's, crossed the T's, independent counsel, yada yada, in terms of the client understands exactly who's going to do what if there's a reversal.
True. Yeah, I had. That's a great puzzle to work through. I would probably keep it in my client trust account. But I think there was another chapter of the Dr. Leavell saga where something similar happened. There was a substantial amount collected during the appeal, and then it was reversed. The judgment was reversed, and then there was a restitution award under Code of Civil Procedure 918, which, as you pointed out, with interest. Yeah, it's just like a regular judgment, just go in the other direction.
Yeah. Wow. Reversal of fortune.
All right. Well, I thought that we would end this discussion about fees and costs award with a brief discussion about enforcement of fees. So this is separate from appellate fees. If you have lost your appeal and the respondent had aggressively enforced the judgment, consider paying the entire judgment amount plus interest, fees, and costs immediately and in cash, because here's why. So here's where this can come up, Jeff. So you've taken this judgment up on appeal, and this time you've lost. Okay, it was not successful, but in the meantime, the other side has been just going gangbusters trying to enforce that judgment. So they're going to be filing a motion to recover their enforcement fees as soon as remitted or issued. As soon as they get back to the trial court, they probably do. I don't even know. Do they have to wait until remitted or issues for that, Jeff? I don't know that they do. Isn't enforcement a collateral proceeding?
Oh, no. Right. Just enforcement? No, they don't have to.
Yeah.
Right.
But they might, as a practical matter, wait until they get back, and then they'll file their motion for appellate fees at the same time, and they'll file their motion for enforcement fees. So if you know that, okay, a big fat motion for enforcement fees is coming down the pike, and I know I've lost on my appeal, go ahead and just pay off the entire judgment amount against you. You're going to have to do it anyway. And if you pay it before, if you beat them to the court, if you pay it off before they file their motion for enforcement fees, it cuts off their right to enforcement fees. And the case on point is a Supreme Court case, conservatorship of McQueen from 2014. The plaintiff there prevailed in a suit for financial elder abuse, which was affirmed on appeal. But while the appeal was pending, the plaintiff incurred an enormous amount of fees to enforce the judgment, including filing a whole separate action for fraudulent transfer. Just 10 days before the plaintiff moved for some $300,000 in enforcement fees, the defendant went ahead and paid the entire underlying judgment amount, including all post-judgment interest.
But what's the story with it having to be in cash? Can't you be presented or tendered with just an ordinary vanilla check or a certified, a cashier's check?
No, it has to be in cash because I forget what the statutory mechanism is there, but it has to be satisfied in full, and satisfaction is not deemed to have occurred until the check clears, basically. So the judgment creditor has to have deposited it. It has to clear.
So,
what a wire transfer seems like it might be the equivalent of cash, but I don't know that. But the McQueen court specifically lays out here that it would have to be a cash payment if you wanted to enforce this statutory rule.
So if a savvy creditor got a check and then realized what the other side was doing, could the savvy creditor's lawyer, sit on that check, file a motion for additional enforcement costs, and then while that motion is pending, then cash the check, or wait till the hearing is held on the motion and then cash the check?
Yes, you could sit on the check. I don't know how long you could sit on the check and refuse to acknowledge satisfaction of judgment before you could get into trouble. That seems like an ethical problem to just refuse for an unreasonable amount of time to acknowledge satisfaction. But here was the kind of the money quote from the Supreme Court on this point. The court says, conceivably, a judgment debtor could satisfy the judgment by tendering cash for the full outstanding amount with interest before the creditor has sought his or her enforcement costs and fees, though this is likely to be rarity for sizable judgments. If the creditor has reason to believe that cash may be imminently tendered to pay the judgment, prudence counsels filing a motion or memorandum for costs and fees accumulated to that point. If the judgment is not then satisfied, any costs or fees accruing later may be sought in a supplemental motion or memorandum. In any event, the possibility that some wily judgment debtor may make a cash payment timed to foreclose a final motion for costs and fees does not provide this court authorization to ignore the explicit, unambiguous language of Section 685.080 under the Enforcement of Judgments Law and substitute a quote-unquote reasonable time rule of our own invention, end quote. So the court says we're driven by statute here. The motion for enforcement fees has to be filed before the judgment is satisfied. And if it's satisfied, then sorry, you may have justly accrued, in this case, $300,000 or more in enforcement fees, but they all go away if you don't file that motion before the judgment's satisfied. But to satisfy it, it has to be hard, cold cash. Cold, hard cash. There you go.
All right. We were going to be talking about attorney's fees and costs today. There's a recent California Supreme Court case I wanted to chat about briefly. You just discussed a case where the courts stuck to the words of a statute, and so they were bound by those words. I'm going to talk about an instance where maybe the clear words of the statute were not considered or stuck to. This is Travis v. Brand, a case from my neck of the woods arising from a political dispute in Redondo Beach. There was a lawsuit brought under the Political Reform Act. And the issue that went up on appeal was an issue of almost $900,000 in attorney's fees. The trial court awarded in favor of the defendant against the plaintiff. Now, the California Supreme Court overturned that fee award because the trial court didn't make a finding that the lawsuit was frivolous, that it had been prosecuted in bad faith or continued in bad faith. And there are lots of public interest statutes that talk about asymmetrical fee award standards where one side has a higher burden of proof than the other to get fee awards. I'm thinking about Public Records Act and the Brown Act, where if a member of the public sues the city or the of a public agency, if the plaintiff wins, they get their fees no matter what. If the city wins, the public agency wins, they only get fee awards if there's a finding of bad faith. Now,
But
it turns out
that bad faith finding is not statutory. That was something that the Supreme Court imposed here.
So what I'm just saying is, yeah, in the instances that I just talked about, Public Records Act and Brown Act, it is explicit in the statute.
Yeah.
It is not explicit in the Political Reform Act.
I see.
And so the trial court just said, well, defendant won, no finding of bad faith, and awarded them nearly $900,000 in attorney's fees. The California Supreme Court reversed and remanded for determination. They're not saying you can't get fees, just a determination by a lower court as to whether or not there was a frivolous lawsuit here before fees could be awarded.
Yeah, that's interesting. I like where the court is going with that. It seems like that's something that that would be an appropriate asymmetrical amendment to the statute. But is that appropriate for the Supreme Court to be imposing that into the statute where the statute is silent on it?
I'm a big fan of public interest lawsuits like actions under the Political Reform Act, and you don't ever want anything that's going to chill plaintiffs from filing such suits. But it's an odd result. I'll tell you another oddity. I don't do a whole lot of California Supreme Court work. The California Supreme Court remanded this to the Court of Appeal to determine whether or not the lawsuit was filed frivolously, rather than the trial court. And maybe the Court of Appeal in turn will punt to the trial court, but I'd be hard pressed to understand how the Court of Appeal could make findings unless they took evidence or something.
Yeah, I wonder if that's the normal procedure. They just punt it down the next proximate level, and then the Court of Appeal, like you said, may decide to just punt it back down for a remand finding. That might be a question I'll have to ask David Ettinger about, that, our Supreme Court watcher.
Right.
That is interesting. So that came up from the Court of Appeal. Did you happen to know whether the Court of Appeal had come to a different result than the Supreme Court?
If I recall correctly, the Court of Appeal had affirmed that the trial court acted well within its discretion in making its fee award. And the California Supreme Court said discretion's not enough. This is an asymmetrical situation. You need a higher finding of bad faith or frivolousness by the defendants here, or by the plaintiffs.
Yeah. No, good topical tidbit, Jeff. And you have a couple other tidbits you wanted to share today.
Yeah, two bits of news. One, LA Superior Court. We're always talking on this show about the lack of court reporters and the problems that it causes for appeals. And the LA Superior Court just recently announced a new initiative for offering financial incentives to find court reporters. And we'll put a link in our show notes to this announcement. But basically, the court is going to be offering increased money for court reporters, student loan forgiveness for court reporters, bonuses for court reporters have been around for a long time, and finder's fees for court employees who refer court reporters back to the court. So I thought that was interesting. But the press release has some really interesting language in it that about the impact of a lack of record and access to justice, that I think if any lawyer at the trial or appellate court is litigating an issue about the absence of a court reporter and an access to justice, it's great language in there that you could cite.
Yeah, well, that is interesting. We're really scrambling here to make up for this court reporter shortage, and it has been reported that this is not an issue of money. There's money in the budget for court reporters, but it's there's just a lack of supply of court reporters. Not enough new people are entering the court reporter profession, and as the ones that are there age out or retire out, they're not being replaced. So it's interesting to see that the court here is acknowledging that by incentivizing student loan forgiveness so that court reporters can go to the court reporter schools and get the training. It's a very, very difficult, very taxing process to become a court reporter. I was not aware that the pass rate for the examination is very low, well below 50%. I can't remember the specific number.
Oh, wow.
Off the top of my head, but there's just a diminishing number of new entrants. So yeah, this is a interesting attempt at a solution to the problem here.
All right. And then the other tidbit I gleaned from Ben Schott's wonderful blog, the Scan blog. If you're going to be having oral argument in the 2nd District, downtown LA, from April 10th to June 2nd, plan on doing it remote. The courtroom is actually going to be closed. They're going to be doing some technical upgrades to the courtroom. So remote arguments from April 10th to June 2nd.
Yeah, that's a pretty lengthy shutdown of that Ronald Reagan building. So, all right. All right. Well, I think that wraps us up, Jeff. We want to thank our sponsor one more time, Case Text, for sponsoring the podcast. Each week, we include links to the cases we discuss using Case Text, and listeners of the podcast can find a 25% discount available to them if they sign up at casetext.com/CALP. That's casetext.com/CALP.
And if you have suggestions for future episodes, or you want to email Tim about why he's wrong about slap fee awards not being stayed, go ahead and email us at info@calpodcast.com. And in our upcoming episodes, look for tips on how to lay the groundwork for an appeal when preparing for trial.
All right. See you next time.
You have just listened to the California Appellate Podcast, a discussion of timely trial tips and the latest cases and news coming from the California Court of Appeal and the California Supreme Court. For more information about the cases discussed in today's episode, our hosts, and other episodes, visit the California Appellate Law Podcast website at calpodcast.com. That's calpodcast.com. Thanks to Jonathan Caro for our intro music. Thank you for listening, and please join us again.